Hello, welcome to another interview with Litigators Corner. I'm here today with John Baldivia. John is an entertainment law litigator with the Pierce Law Group, and he has generously agreed to offer his time today to tell us about some very interesting cases that he's working on and to talk to us about some of the common things that their firm sees with the entertainment industry that can lead to litigation and to give us some tips. John, how are you today?
I'm well. Considering everything with COVID going on and my kids having to stay home from daycare quite often, doing pretty well. Had a few recent victories in litigation this year, and so those are a couple things that I'm kind of writing my head on right now.
Well, I'm glad you're here. So I know that we've talked to your managing partner about the Pierce Law Group, but tell us a bit about yourself.
I am as you had said, I'm an entertainment litigator. I actually come from a background in the music industry. So prior to doing litigation, I was working for both independent and major record labels on the content distribution side. Mm-hmm. I did that for about 10 years, and I was going to law school simultaneously, and that's when I made the transition from working in music distribution to becoming an entertainment attorney.
Oh, so you really know all the aspects of the industry. That's great.
I know quite a bit about the entertainment industry from being involved in it in so many different aspects, yeah.
Well, I bet that makes you a lot more valuable to David and to the Pierce Law Group and to our legal community. So I know that your firm works on some really interesting cases. Some of them are really at the forefront of changes in the law, and I know that we had talked about a couple the other day. In particular, there was a copyright infringement matter that you've been working on that you're particularly proud of?
Yeah, so recently we were involved in a case. The case was entitled Bain versus Film Independent. For our purposes, our involvement was representing one of the actresses who was a defendant in the case, who was sued for copyright infringement for using part of the film footage in her demo reel. Mm-hmm. The short version of the facts are the director hired the actress to work on a film, and when the film was done, the film was exhibited in various film festivals, and for the purposes of copyright, even though the film had been shown at various film festivals, it was considered an unpublished work because it wasn't released for general sale at the time. As part of the actress's involvement in the film, she was promised that she would get a copy of the film to use for her demo reel. And after some time, the actress got a copy of the film. The film was obtained, as far as we understand, without the permission from the director or who was also the producer, who was also the copyright owner in this case. She then took that film, which was originally 95 minutes, and gave it to a film editor to create a demo reel. The demo reel ended up being 3 minutes and 40 seconds long. There was actually a shorter version that was made too, but for the purposes of the suit, we were, I think, looking at the 3 minute and 40 second version of the reel. For purpose of whether or not there was copyright infringement involved in this. The original film also had a watermark when it was being sent out to the film festivals, and the acting reel after it was edited did not have the watermark in it. The editor received the reel from the actress, being shared through Google Drive, and when the reel was completed, the editor then shared the reel back to the actress using his own website.
Did she ever actually send it to anybody?
No, he did not send it to anybody. Ultimately, what happened was when the editor sent the reel back to the actress, he didn't know, and neither did the actress know, that the video was searchable through Google. I believe the reel was being hosted on Vimeo.com and then linked to the editor's website. And then the editor would then send the URL from that website to the actress. But for some reason, the privacy settings either on Vimeo or the website weren't fully set. And so the director had found a copy of the reel using a Google search. When she found the video on Google, she filed the registration for the copyright, sent the cease and desist letter to the actress, who then complied, destroying all copies and not sending the reel to anybody. And then the lawsuit came 6 months later. So what was really, what we thought was pretty important about this case was that up to that point, we had not seen any jurisprudence that would say definitively that an actor's reel or a demo reel would be considered fair use under the law, under copyright law. And we had always suspected this, and I believe many people in the industry had always thought this would have been the case, but there was no actual public decisions that ruled this, or at least we weren't able to find any. And we didn't see anything in either NIMR or any other treatises that would have suggested otherwise, or suggested what we thought was going to be the case. So when we took on this case, we thought this was going to be a case of first impression, even though it was always kind of a widely known concept that actresses and actors use demo reels on a regular basis, and it's part of industry custom and practice. It's just I don't think it was ever tested in the federal court as to whether or not the reel would be considered copyright infringement. So we had taken on the case, and we had simultaneously filed cross claims for employment violations because, among other things, while she was on set, there were a number of employment violations that were committed. There was an employment agreement that the actress had signed with the director directly. And then 2 months later, there was a new employment agreement that replaced the first one. This time the contract was with the production company and not the director. Important to this analysis is that the contracts, both of them, had the same arbitration provision. Mm-hmm. And when we had initially got involved in the case, one of the first things we did after filing a cross complaint was moving this into arbitration. So this was really an issue where we were trying to compel arbitration against a director who was, technically not a signatory to the arbitration agreement, because the original agreement had been replaced by the subsequent agreement between mm-hmm. with the employee and the production company. The court found that, through principles of equitable estoppel, the director was going to be bound to the arbitration agreement anyway, even though she wasn't a signatory. And the reason is because the director had intended to be bound to the arbitration agreement, as evidenced by her implementing the first contract. The director was also the sole creator and sole operating person for the production company itself. She's the one that signed the employment agreement on behalf of the production company. And she was the sole copyright holder of the film when it was all said and done. So she was ultimately the only beneficiary to the employment services of the actress.
Was it sort of also an alter ego type situation? Because it equitably, I can see where they would come to that conclusion, but it also sounds like they're really just saying you're one and the same.
Yeah, we had raised the issues of alter ego and joint employment in our motion to compel arbitration. Although the ruling seems to echo a lot of those same principles, Judge Anderson didn't really rule it on the issue of alter ego, and I think it's to make sure there was no collateral estoppel that would be in effect because of that kind of a ruling. So, and was
this in Central District and Federal Court here?
This was in Central District, yeah, before Judge Percy Anderson. So he had originally ordered this case to be brought into arbitration. Mm-hmm. Long story short, this case was not arbitrated because under the arbitration rules for AAA, the employer, who was the director in this case, has to pay for all the arbitration fees, and she ended up running out of money in the middle of the process. So, after about a year and a half, this moved back into the federal court. There was a bit of contention as to whether or not we would bring this back into federal court, but ultimately the parties stipulated. So this moved back into federal court. We had both the copyright infringement claims and the employment cross claims in there. And there was also a third party. The editor ended up filing for indemnification against the actress, which was ultimately dismissed in the end. But for purposes of moving back to federal court, that was one of the decisions.
And did this go to verdict, or was it a motion for summary judgment, or how did you proceed?
This ended up going to summary judgment, and we were given a really short window to conduct discovery in this case, even because Judge Anderson had thought this was a case that was simply sitting on his docket for far too long, and he wanted a quick resolution. So, the scheduling conference was in March of this year, right around when the pandemic hit. Mm-hmm. He had ordered the case for trial in October.
Oh, wow.
So we were stuck conducting all the discovery in a span of 4 or 5 months in the middle of the pandemic. So there wasn't a whole lot of time to serve or compel responses if there were any deficiencies with it. So anyway, we ended up filing cross motions for summary judgment. We had filed for summary judgment on the grounds of this being fair use. They had filed for summary adjudication on the employment claims. And I should point out that the complaint that the director filed was for a few different claims. It was a claim for copyright infringement. There was various and contributory liability for copyright infringement. And then there was a DMCA violation under Section 1202. And if you're not familiar with 17 U.S.C. 1202, it's basically a statute that prohibits you from removing a visible watermark or any identifiable watermark from a protected work with the purpose of furthering copyright infringement. So in this case, the claim was involving a watermark that showed up on the film that was being sent to the film festivals. They had said that removing the watermark and creating the reel was itself a violation of Section 1202. So our motion for summary judgment was largely based on fair use, but there was a latter portion of that summary judgment motion was based on plaintiff's lack of evidence of showing intent that the actress had intended to commit copyright infringement when the watermark was removed. And so there are two key rulings that we think came down from this motion for summary judgment. The court found in our favor. First, with regard to the copyright infringement claims, the court ruled that this was fair use. When you're looking at fair use on copyrighted work, you're looking at 4 factors. You're looking at the purpose and character of the secondary work. You're looking at the nature of the protected work. You're looking at the amount of substantiality used in the secondary work, and then you're looking at the effect on the potential market for the original work when the secondary work
is the fourth one where sort of the standard and practice would come in? Because I know that happens a lot where they go, well, this is just industry standard. People use reels all the time. How much did that factor in, do you think?
That factored in more towards the purpose and character of the use. Because as we break it down, you'll see that the reason for why you're creating the reel is what lends it to be a transformative purpose, right? So when the judge had ruled on this being fair use, he essentially said that 3 of the 4 factors had weighed in favor of fair use, and the only factor that weighed against fair use was the nature of the work. The nature of the work being that it was an unpublished film that was, then being used to create an acting reel without the director's permission. However, the purpose and character of the secondary work was transformative in that the demo reel was not used to tell the story of the film. It doesn't serve the same purpose, right? The purpose of a reel is for an actress to find more work so that she can be hired subsequently as an actress for other films.
Right.
The amount of the work that was used in the acting reel, it was a total of 3 minutes and 40 seconds compared to a 95-minute film. That's less than 4% of the film, in substance. So you're not using much of the work. You're only using the amount necessary, that being the amount of the footage that conveys the actress's best scenes, right? The scenes that are capable of showing her range of emotion in the film.
So she can find other work.
Exactly. And, part of the reason that the reel consisted mainly of one film was because this was her first time acting in a feature film. So she didn't really have other sources to pull footage from. So, if she needs to submit a reel that shows her range of emotion and ability to perform, if this is her one film, naturally most or all of that evidence is going to come from that one film.
Right.
The court also then looked at the potential effect on the market that the reel would have had on the finished work, right? The reel itself isn't used to be sold. The actress doesn't get monetary value from distributing the reel other than, the promise of being hired for subsequent work, right? But there's no direct value that the actress is pulling from the copyrighted work itself.
Right, or any third party is probably retaining from it either, because they're just going to look at it and go, okay, well, she's good, we'll put her in and give her a tryout or a...
Exactly. So, when the court was ruling on that issue, basically said there's no evidence of any financial impact on the film. Mm-hmm. That the purpose and character of the reel was transformative in nature, and that you weren't really using more than what was necessary to create the reel. So this all fell within the ambit of fair use.
Well, if you had to point to one factor that you think won it for you, what would you say it was?
I would think it was actually two of them. One was that it's such industry practice for actresses and actors to use footage in demo reels, and people who are in the industry know what the purpose of these acting reels are for. They know that they're not using these acting reels to generate money. They know that it's only being used as like a resume or a calling card, mm-hmm. saying, here's evidence of my work. Please hire me, right? People who are, more prominent, like Tom Cruise, Brad Pitt, they don't need acting reels because people know their work. But for someone like the actress, who this being her first feature film, no one knows what her range of capabilities are, and they're not going to watch the entire film just to see what she can do. So, she has to create these, 3, 4, 5 minute videos to show what she's capable of doing as an actress. And I think the other factor that really did it was the fact that there was no impact on the market. When we're talking about the reels, the reel isn't a substitute for the film. No one's going to go out and watch the reel instead of buying or watching the film. Right. The film was already publicly available on Amazon Prime, and it had been charting for a little bit, even despite the fact that a reel was searchable on Google. So, there really was no impact on the market that plaintiff could show, and so those factors really pushed it towards the finding of fair use, I believe.
Right, and the transformative use, I know we've seen a lot of activity in that area of litigation with lyrics is another one that we see a lot of, and use of music and derivative type works, and whether that's really legal to do. So this is a big area, a lot more in the entertainment industry, but it also affects a lot of other industries as well. And I've seen a lot of very interesting ways people have come in through state proceedings, civil proceedings, federal court. They've found a lot of creative ways to get around this. So I know that you and David are really at the forefront of a lot of this kind of litigation Like you said, was this, I know this was not published, has it been appealed, or did they give you attorney's fees? What happened here?
Well, the court was unfortunately kind of fed up with this case at that point. So even though the court did find that it was fair use, the court basically said each party has to bear their own costs, and please don't consider trying to come to
Don't
me.
come back.
So as you know, there's been no notice of appeal that has been filed. Although technically today is the last day to file a notice of appeal. But we haven't received any indication that an appeal is in fact going to be filed in this case. So we don't really see this going any further.
So you don't have to hold your breath over the weekend?
Well, we don't have to hold it over the weekend. We maybe for another 12 hours or 11 hours or so, but that's really it.
And did you conduct all of this by the hearings and everything by Zoom? You weren't actually in the court? Is that how?
We did all the court appearances telephonically. If you've been before Judge Anderson before, he likes to rule on things before the scheduled hearing. And so whenever there were motions that were filed in this case, we ended up receiving the rulings maybe a week before. And that was the same case for the motion for summary judgment, is that there was a hearing set. Typically in federal court, it's 28 or 35 days out with Judge Anderson, but he had ruled on it, by the third week.
It sounds like he was very judicious in this case and was monitoring closely. It sounds like he had his eye on it.
Yeah. I think especially once it came back to his docket, he was really anxious to see this come to resolution.
What do you think this means for actors and actresses and production companies when they have these?
Well, I think the lasting impression that this leaves is that there's going to be no question that an acting reel is fair use under the eyes of copyright law. Now, whether or not there's going to be other remedies that you could put in a contract, with an actor or actress to prevent from this happening, that's a different story. But long story short, you shouldn't really be coming after your actor or actress for copyright infringement if all they did was create a demo reel based on the footage.
Right. There's I would think a big win for any actor or actress, particularly one that's new to the business or has, wants to create a body of work and hasn't done that.
Yeah, certainly. There was also one point that came down in the ruling on the motion for summary judgment that I thought was kind of important. A couple of years ago, there was a case, Stevens versus CoreLogic. This is in regard to the 1202 claim, the removal of the watermark. In Stevens versus CoreLogic, the Ninth Circuit essentially ruled that if you're going to bring a claim for violation of Section 1202, you have to show evidence of intent. There has to be a mens rea component to bring that claim. And when we're looking at what happened in this case, where the actress sends a full version of the film with the watermark to the reel, to the editor. The editor then removes the watermark for the purpose of creating an acting reel and then sends that back to the actress. Plaintiff contended that those two acts were separate violations of 1202. And the court had found that, for one, when the actress sent the full version of the film to the editor, and that full version of the film still had the watermark on it, there was no violation because there was no risk of confusing the editor to believe that she was the owner of the film. And then when the actress then received the reel back without the watermark, the court had already ruled that the creation of the reel was fair use. And plaintiff's claim was that by distributing the reel, she was then receiving an unauthorized work that had a watermark removed with the intent to commit copyright infringement. But you can't violate Section 1202 if the underlying act itself is fair use.
Right.
And I think that's the first time that we've seen a case where a 1202 violation was was dismissed based on the underlying activity being ruled fair use.
Yeah, so that has a lot of ramifications for our entertainment law industry, and I know for those of us who handle these these sound like a simple ruling, but they're actually a very complex array of legal and procedural issues, as well as factual issues that need to be addressed. So I really commend what a thorough and professional job, because you guys make it sound so easy to do this, but as anybody who's a litigator knows, this is so time consuming and requires so much thought and preparation to do that. So it sounds like it was a good win for you. And
yeah.
You had another matter that you've tried recently, and that you were also thought would be nice to share with everybody here. So why don't you tell us about that?
Yeah, there's another case that we were involved with, and unfortunately, it's one of those typical Hollywood stories that you hear investors get roped into, right? This case is a case that we ended up getting a judgment against the defendants. The case is entitled Relay versus Dawkins on the state level in the Superior Court in the Santa Monica Courthouse. Essentially what had happened was our client is a prominent individual in the Philippines. And she had a daughter who was working her way into the music industry. She met a producer who essentially tried to sell her hopes and dreams, right? So she had told the plaintiff, who's the mother in this case, that as long as you finance the project, we'll get this, we'll get her career started for you. The plaintiff ends up putting in over $3 million into this. Meanwhile, the producer is promising that he has relationships with Bruno Mars, says that he's going to get artists like Mario or Kehlani or T-Pain or Chris Brown to perform on this girl's first album. It turns out, as the case is developing, one of the artists comes out on her social media and says, "I've never even heard of this producer. So I feel bad that he's using my name to steal money from other people." So one of the other artists who the daughter had developed a friendship with had basically told her, "I don't know if you realize this, but I'm not receiving what the producer is telling you to pay." So, the producer's upcharging the actress fees and presumably pocketing it for himself.
Right. So not only professionally embarrassing her, but in breach of contract. Right.
And meanwhile, the producer's also saying, we need a radio budget, we need a marketing budget, we need you to invest $850,000 to create a music publishing company. We need some money so that we can get this music featured on a show on Netflix. And anyone who's familiar with the industry knows you don't need startup funds to create a music publishing company. You don't pay to get your music placed on a film on Netflix. They pay you.
Right.
And if you're going to be paying for a radio marketing budget, you would expect to see some results. Well, the plaintiff had been paying this fund for about 5 or 6 months before even one of the songs showed up on radio. Mm-hmm. In total, I think the producer ends up, saying he's going to produce 16 different songs for the artist. Only ever completes one of them, and by the end of 1 year, $3 million down the line, the case goes into litigation, and we filed the suit. So when we had initially filed, we actually brought this case to early mediation. About 3 or 4 months after filing, this went to mediation and it settled. However, the defendant in this case thought that entering into a settlement agreement itself was the end itself, and didn't even bother to pay the settlement.
Which does happen.
it happens, and there's two schools of thought, right? Well, either you can go back to the court and enforce a settlement agreement, or you can reopen the case for litigation. In this case, we thought that it was strategically better for us to just reopen the case because the settlement was less than what the amount of the damages were. Right. So a year after litigating the case, we go back to mediation again with the same mediator, and this time we end up with a stipulated judgment for the full amount, presumably because the defendants saw the mountain of evidence that we had and didn't want to end up taking this to trial and risk punitive damages.
Right.
So we end up getting the judgment for the full $3 million, and we are now in the midst of collecting that. I think.
Does he have any money?
He's rolling around with some expensive cars, and he's got real estate. So, I don't know if I'm how much in detail I'm allowed to go into this, but we do hear that he's playing the same con on other people.
Oh, I'm sure.
And so, for whatever reason, there's money there somewhere. He has a stake in the publishing catalog that we know is generating some revenue for him. So, there is money. Whether or not it's, enough to cover the full judgment, we're not really sure yet, but we're in the process of discovery for that.
Great job. I know that we've talked about this, and we get a lot of these too when we handle it. I know this is a common situation with, which is another topic that we're going to get into, a common situation in the entertainment industry where you're pretty much selling, say, look, you pay me this amount of money, I'll make you a star.
Right.
So you're pretty much paying in to make all this money. And sometimes it probably does work. I mean, I don't think it doesn't always work, but I think by and large, there are these con artists who are exploiting and taking advantage of people who really, some of them, it's their life's passion, or maybe they desperately want to get into a business like this. And what are some of the common cons that you see? I know that your firm is unique in that you handle a lot of these cases. You're handling the con jobs, the fraudulent investments, things like that. What are some of the areas that you see?
Well, we do a lot of representation for independent films, and so when we get involved, there's a lot of times where we're talking to investors who had been putting upwards of millions of dollars into independent films, and it would be a scenario where because we do both transactional and litigation at this firm, we will get involved in the film finance portion of it, draft the private placement memorandums for the investor to get involved in the project. And then the film producer would just run away with the money. So, what's unique about our firm is because we were involved, because we do both sides, we know all the facts that happened during the transaction. And we are then able to go out and pursue the bad actor for the breach of the contract. And not only that, but fraud. And so, we do see that happen a lot, unfortunately, especially in the independent space. I think partly, I don't know if it's more so that there are just con artists out there, or if there are just a lot of people who promise more than they can actually deliver. And I'm not, or both. I'm not really sure. If I can say one way or another which one we see more of, because we do see both happen. Another thing that we see come down the lines with regard to investments are issues that would otherwise be securities law violations, right? Because we are representing people with money who are putting in their funds to help create a project, and a lot of times we will get involved with the investor only after the money had already been invested.
Right.
And so when you when we're doing client intake and we're asking the investor what agreements they had in place, you're seeing these little 1-2 page agreements that basically says, I'm going to give you this money, you're going to get this much in return back with the gross profits. Well, no one's telling these people that when you're taking money and putting into a passive investment, you're essentially selling a security, and you're triggering SEC violations, right? Obviously when we're doing it, we're taking the necessary measures to make sure that we're in compliance with all the necessary rules, doing things under private placements, make sure the necessary disclosures are being made.
But most people don't probably go into that level of detail.
Right. And, it's unfortunate that when the investors are coming to us, it's already after they had spent the millions of dollars on the project, when, it would have been wise for them to take, 5% of that budget and have a lawyer just look over it.
Right.
Protect their investment in the first place.
And do you see that often if the person had just come to a lawyer? I mean, I think in any part of the legal profession, you say, I really wish you'd come to me before you did this, and they're coming to you afterwards and going, this is kind of a mess, and I don't know where everything is. And,
unfortunately, that is the majority of what we see.
Mm-hmm.
We for a lot of the cases that come through our door that we can say we see a lot of them of it. Many times it's because, they had thought that they were all friends and everybody was, good with the deal that they were getting into until one day they weren't.
Right.
And, at that point, they're not thinking they need lawyers because it's just going to sour the relationship or because it's going to cost them money or whatever the reason. Mm-hmm. We see plaintiffs, come to us saying that here's the mess that I'm involved in. And you're right. Really, if they had just gotten an attorney to help them out from the start, they wouldn't have been in the mess in the first place. For example, I'm sure many other entertainment firms or any firms in LA are seeing people who come with copyright infringement issues, right? These are writers who had written a script and then had someone who was either a co-writer or a producer run off with the script and get it produced without the writer's involvement. That's one of the types of cases that we see here, and really those can be broken down to either claims of copyright infringement or accounting claims or idea theft claims. And usually it's broken down to if it's the writer who wrote the script and then a producer ends up taking it, then there may be a copyright infringement claim. If it was a co-writer taking the script and running off with it, then it's not really infringement because the co-writer has his rights in his or her rights in the film too. So it's more of a claim for accounting. And then the idea theft cases, which we colloquially call Disney cases, ideas that were pitched to somebody with this intent of being compensated for the idea. That person then runs off with the idea and gets the film made. There's no infringement claim because nothing was put, down on pen and paper. But there was this implied contract that if I tell you my idea and you take it, you're going to pay me. So we see a lot of those types of claims coming through our doors. And the kind of the underlying message that we always tell those clients is that you need to register those scripts with the Copyright Office early, before it becomes a mess. We'll often see people, potential clients, who tell us that they registered the script with WGA and not the Copyright Office, and they think that they're protected by doing that.
And that's a common misconception. They're like, "Oh, I've put it in the little vault or whatever it is, and so I'm not going to get a claim." That happens often. That is true.
Yeah, it really does, and we have to inform them that, look, sure, you're protecting your credit, but you're not protecting your ownership in any of the copyright. And until you actually file the registration for the copyright, you really can't do anything in the legal process through it. And now the fact that you're registering the copyright after the fact, you don't get an opportunity to get statutory damages or your attorney fees paid back, which makes it a lot harder for you to get representation without having to pay an attorney by the hour.
Right.
So
Particularly if it's one of your first scripts or you're not really well established and don't have the financial backing to be able to do that.
mhm.
I know that you had talked about there are some emerging issues in the entertainment industry that your firm is dealing with a lot. I know there's some employment law issues and things like that that we've touched upon. Can you tell me what you're seeing generally as some trends in this industry when working? Because you would do a lot of work with production companies.
Yeah, so like I was saying earlier, we work with a lot of independent productions. And what we've seen, not necessarily from our clients, but from independent productions in general, is that they're not cognizant of the new laws that are coming down in the state of California, especially with regard to AB5. Actually, even more so, just treating cast and crew as employees of the producer. California has long held that people who are hired as actors and crew members are considered employees of the production, and so you're subject to making sure that you're complying with the labor code, right? Mm-hmm. Making sure that you're providing adequate meal breaks, making sure you're paying appropriate minimum wage, paying overtime, paying people with itemized wage statements, making sure that when you're paying people their wages, you're paying them on time. We've had a number of production companies come to us because they're running into these labor code violations, simply because they didn't know the law, right? They didn't know that you can't hire an actor or actress as an independent contractor. That's actually something that was happening in the Bain versus Film Independent case. The director had tried to hire our client as an independent contractor, when she was the lead actress for the film. So they're hiring them as independent contractors. They're saying, we're just going to pay you this flat amount, and you're going to work 12 hours for that flat rate. And then, of course, when production happens, they're going well into 14, 16 hours and not taking into account that you're well into double time at that point.
After 12 hours, yeah.
Right. And so for these independents who don't have experienced UPMs, who know that these labor laws exist, they run into issues, right? We've had 2 or 3 production companies, at least in my time, come to us saying that they were hit with PAGA claims simply because they weren't classifying their employees properly or paying them properly. Or in one case, we had someone who was trying their best to abide by the laws and even got a payroll company involved. And the payroll company not only paid the actors late, they also messed up the wage statements. Oh, and
yeah,
so
I've heard some horror stories about things like that. You have to be really careful when you're dealing with a third-party vendor.
Right, and of course, with the contract, there's probably some indemnification provision that's in there, saying that if the payroll company is the one that messed it up, I'm going to come after you for damages. But your indemnity is only as good as the person that's indemnifying you.
Yeah.
So, we've had clients come to us with those kind of claims, and I think that in the independent space, because people do so much of it in California and just aren't aware of what the labor laws are, they just run into issues, and it's unfortunate because I think that many of them are getting their what they believe to be commonplace practices from experience that they were doing out of state, right? Like they were
before the law changed or before anybody clamped down or things like that. Right. What if you had to look at a production company, what advice would you give them on across the board about compensating cast, crew, things like that?
I would say that getting payroll established is one of is a really important part of making sure that you're complying with the labor laws. No, I know I just mentioned the horror story of a payroll company resulting in PAGA suits, but I think, for the most part, the payroll companies that we know that are doing a lot with entertainment production companies really know what they're doing, and are able to not only get things right for the production companies, but can actually steer them in the right direction if they have questions. That's really important in terms of protecting them from running into issues with employment on production. Making sure that you're having an attorney review your form contracts when you're hiring cast and crew. A lot of times the issues that we see are producers who are trying to make their own chicken scratch contracts because they had seen it once upon a time, either when they were an extra on a set somewhere or when they were acting somewhere. They had basically taken their contract and then reformatted or repurposed it, taken out all the guild language and whatever they thought was unnecessary, and not knowing that quote unquote unnecessary language was really what was complying with the labor code.
Right, exactly. Or they see the templates, you see a lot of those online where there's templates and you can just fill in the things. I'm actually preparing one right now where I'm looking at it and it's an app and I'm going, oh, you're looking at all the, they even had some blank things, fill in this and things like that. I mean, it had some of the points were there, some of them weren't, and they're like, oh, I hadn't really thought about those. They just fill it out. It's like just type in the answer and then they think they're done with the contract, and knows how legally binding it really is.
Right. Yeah. I mean, it's interesting. I've even seen some of those chicken scratch contracts have arbitration provisions.
Yeah.
And I'm thinking, I don't even know if you understand what arbitration means.
I don't know that a lot of them are enforceable either. Some of the ones I've read are like a few sentences. They don't say anything. They don't have the new language. I mean, ours are pretty extensive, but they don't have anything about, the current state of the law or who pays, or, some have mediation, but some of them don't say you waive your right to a jury trial and you understand and acknowledge this, which makes it void on its face. But, things like that where there's no detail there that would really help. And they're like, oh, I thought we were doing it correctly.
Right.
It's just sort of a lack of knowledge about what labor laws are. Are you seeing the same situation, not just the cast, but the crew, like the lighting and things like that, where people are coming in and people are doing hair and makeup and things like that are not being compensated properly?
I think with regard to crew members, really the kinds of claims that we're seeing come from them are people who just aren't being paid on time.
Okay.
And under the labor code, there's a set schedule as to when you're supposed to pay your crew once production's finished, and they're paying maybe 30 or 45 days later because they think they can pay them that 30 by calling them an independent contractor.
Right.
And then a few months later, they're getting PAGA notices saying that you didn't pay on time, and you probably didn't pay the rest of your crew on time, and so here's a lawsuit.
Right, exactly. And you had me here every day and I couldn't leave and I had to be here at a specific time and do exactly what you said. And, so I was an employee.
Yeah.
Well, John, what tips would you give for the entertainment lawyer in this, or litigator in this areas? Because, a lot of the work we can do now is preventative. We can prevent a lot of these things from happening if we just know the proper documents to sign and what to advise our clients. What advice would you give entertainment litigators in this current environment?
I think for entertainment litigation, there's a lot that's changing with regard to copyright, especially when you're seeing companies like Netflix who are really on the forefront of pushing the boundaries of fair use. Right. Before Netflix had become the giant that it was, studios in general, and it kind of still is a practice, they were scared to death of any copyright infringement claims, and they would take whatever measures to do to prevent it on the production. And when the film was ultimately completed, saying that, if it's even questionable whether you can use a copyright or trademark without consent, it shouldn't be in there. And, I think we've seen a company like Netflix rethink that that train of thought and say, you know what, we're going to take this through. We're going to see to the end of the claim and make sure that it is fair use. And we've seen a lot of studios come out on the right side of this.
Right. Which is a huge change from the way things were done before.
It's a huge change. And so, not only for entertainment litigators, but for production companies, when you're looking at clearance issues for copyright and trademark, really staying abreast with how the law has changed in just the recent years is changing how much you can actually get away with without a proper license in place.
Right.
Yeah.
It is. It really is. Well, John, you have such an interesting background and such a wealth of knowledge. I know I've learned a lot today just talking to you, and I appreciate you making the time to share this with us. And thank you so much. And I know that you, David, and I were talking about some other matters. So thank you.
Great. Thank you so much for having me.